Okay, good morning, everyone. We'll open up the Commerce Committee's hearings, and we have the first bill, House Bill 1146, relative to condo instruments and condo special assessments, and hear from the prime sponsor. Good morning, Representative Lehman.
Good morning, Chairman Hunt and esteemed colleagues. Well, this bill, I'm sure, is very unpopular, but I put it in not only because I've been president of our association in Rochester at least 2 terms, and I've been on our condo association committee, the board of directors, for decades. I am no longer on the condo association board of directors. However, I do keep my finger on the pulse. And I understand all of the complaints that I've gotten in my email. But the purpose for this was that this last time that we had an increase in our condominium fees, it was quite a jump, and the association members were angry. And so we talked about it, and they said, well, we just voted, a majority of us, a pretty good majority of us just voted to stop this fee from going in. Why didn't that work? And I said, because you need 2/3. And so out of 60 units, which is the size of the condominium association that I'm a member of, and I've owned 2 condos, and I've been there since 1995. So I don't even want to count how many years that is. It makes me feel old. So I said, all right, let's try for a simple majority, which would be 50% plus 1. And at that point, the association members would have been able to reject the decision of the board of directors. And I know that that makes everyone very nervous, because now the association owners and members actually have a say, instead of letting the board have the say. And I understand representative boards, so there's a lot of tension. But I wanted to put this in because they wanted to have a say. I did not touch the 2/3 for any other decisions to be made. We just carved out the fees, and that was going to be it. And if this doesn't work, I'll just work on the 40 members that will need to override the board of directors next time, because we got really close. But they were angry. I was kind of upset too because of the jump in the fees. It was huge. And so that's why I've submitted this piece of legislation in hopes that it will pass, but I know that it won't. Thank you very much for hearing me.
Do you have any questions from the committee members? Yes, Representative Van Houten.
Thank you very much. When you refer to as condominium fees, are you talking simply about the monthly fees, nothing else, no assessment, trash fees, anything of that sort? Thank you.
Yes, thank you for the question. Yes, that is correct. So none of the other decisions by the board would be affected by this. They still remain at 2/3. It really is. Oh, and I did get a call from a banker or bankers that were concerned about the condominiums being able to, the associations being able to procure loans in case that there's a need for it, which we've had several situations where we've had to get loans for the association. And when I took out or added in, I can't remember which one it was, but the special assessments weren't touched either. So that made them happy. And they're like, fine, we see no problem with this. So really, if you have a roof problem or you need to do siding or something happens, we actually had a section of our condos are not stacked. We have sections of condos. And so there was one section that actually burned terribly, and that whole thing had to be rebuilt. Those members of the association were displaced and had to live in a hotel for months. But we did rebuild. So at that point, we needed to get a loan for some important things, and we were able. I just know that being on the board, being president of the board, and having subcommittees that I had formed and the whole 9 yards, that we were doing just fine with maybe incremental condominium fee increases before the 2/3 law went in, and special assessments were you know, nobody likes a special assessment, really. I mean, you know, how long do we have to put up with this? But the special assessments worked just fine, and then when they peel off, then you're back down to a reasonable level instead of having to maybe, you know, supplement in cases where there may be a tree that goes through a roof or something like that. So, sorry to have such a long answer. Thank you for the question.
Representative Burrows.
Thank you, Mr. Chair, and thank you for taking my question, which is, I was wondering if you've spoken to other stakeholders who may feel that this is problematic beyond your own condo association?
I have had some conversations with them, and I do understand some of the problems that arise as far as the lack of involvement of, and I understand this. I understand the whole, I've been there, been on the board plenty of times. And so the reason why I have introduced this bill is because we were wanting to turn it into a simple majority, but I know that it does raise some problems. But then you also have, you know, I read one email where from actually a friend, someone I went to school with in Laconia, and he said, well, by having the 2/3 put in place and into law, that prevents the association members from being able to override the board. And I just thought to myself, good Lord. So by putting the 2/3 in, you completely take the voice away from the members. Unless you really push it, which I'm able to do because I'm really pushy. But yeah, I do, I understand both sides. But I'm hoping for a...
Sorry. Follow-up, please.
Further question may inquire.
So I believe, if I'm wrong, let me know, isn't there a statewide association that represent condos? And if so, have you spoken to them, and what's their stance?
They don't like it. That's the short and sweet answer to that one. Yeah.
So, needless to say, you have no other supporters for this bill. I mean, I get a whole pile of people who are opposed to it. So, and this committee has, not only did it pass it, and we've had this issue, try to repeal it and revisit it several times. So we all pretty well, but I want to take this opportunity just to make sure that some of my thoughts and arguments are still true. So you are a board member, did you say?
I was. I am not currently a board member on the Association Board of Directors. I have been president 2 terms, and then, you know, other terms I've just been on the board.
So when this big raise came, you were not on the board at the time?
No.
Okay. I assume that the board made a big presentation about why the increase was so large?
Well, there wasn't much of an explanation. We didn't, those of us who disagreed with it voiced our opinions, and our board doesn't like to communicate very well. So there was not a whole lot of back and forth. It was just a kind of a shut up type of a deal.
Ouch. Okay. So, and we have heard this before, that boards are maybe aloof or elitist in some way, but I was intrigued by the idea that you were actually on the board for a while. So which, of course, this was never a problem when you were on the board, right? You never, no. Yeah. So the question then is, do you plan to run again? In the House? No. For the condo boards.
Well, probably.
Okay, because we would think that one of the resolutions of this problem would be that maybe the board needs to be replaced with people who are more communicative to the condo owners. Would you believe?
Yes, I would.
Thank you very much. Okay,
Thank
like
you.
I said, everybody's in opposition. This committee has pretty much been on record for years is in support of the current law. So please don't belabor too much, but I know that you all came up here and want to make sure we get it. So we'll start out with Gary Doderium. Good morning. Make sure you push the button. There you go. Perfect.
Okay. Sorry about that. My name is Gary Daddario. I'm an attorney that practices community association law. I'm a partner at the firm of Marcus, Rico, Emmer, and Brooks. But I'm here in my capacity as the chairperson of New Hampshire's Legislative Action Committee through the Community Associations Institute. I'll try to be brief, especially given what you just said, but I do just want to convey some information to the committee regarding this bill. So associations in this state are nonprofits, and so the only financial resources they have are the assessments they collect from their unit owners. They have, of course, important business to take care of with that money: insurance, electricity, landscaping, snow removal, things of this nature, and all that they have to work with is the budget that they establish and then the assessments they collect from the community. And I mention that only to make clear that to the extent that the board ends up with their hands tied about the amount of money that they can collect, there isn't an alternative resource. It's not like they're going to dip into profits or something like that because it doesn't exist for them. Just a few years ago, in 2016, when there was a large amendment passed to 356B, the Condominium Act in this state, one of the things that was included was an explicit fiduciary obligation that the board has to the associations. And so I think it becomes that much more important when a board is saddled with a fiduciary obligation to do what's best for the property. I think it becomes that much more important to allow them to do their job. For them to be hamstringed with something as important as the financial resources that are going to be collected over the course of a year and used for the property, I think can put them in a very difficult position depending on what the needs of the property are. And of course, by way of reminder, boards are elected by the community, which means that in a community where the majority of people don't like what the board is doing, they have the ability at the next election to replace all or some of their board. That's what happens when the elections occur. That maintenance, the taking care of the property that the board does with the funds that they collect, goes well beyond aesthetics. I think, unfortunately, some folks erroneously believe that it's really just a matter of to what extent a community has curb appeal. But it goes much deeper than that, especially when a property starts to lose curb appeal and then problems sort of further develop. We have all at this point heard of the tragedy that occurred in Florida, the loss of human life in a building. I will tell you that Community Associations Institute operates on a national level. And in response to that incident, they established 3 national committees to study what went wrong and how that might be avoided in the future. I was asked to serve on 2 of those national committees, and I did so. And I will share with you that what came out of those committees were essentially 2 primary recommendations. One, that buildings get inspected more frequently by persons qualified to perform those inspections throughout the life of the building, especially as it ages. And 2, and this relates to the ability of associations to conduct that first aspect, the second big recommendation was that communities have to do a better job of raising funds so that they have the money that they need to address problems when they're discovered. It turns out that down there was a lot of arguing, that it was known that work needed to be done, and there was a lot of arguing about it based on the cost. And unfortunately, that's typical. It's basic human nature for people to not want to have to pay more money. And I can tell you, since working with boards is all that I do, boards don't love raising condo fees. They are owners as well, and they pay those same fees. So they're getting hit with whatever increase they apply to the community as well. In addition, the board members feel the ire of the community. So they don't take it lightly, and they don't want to do it, but there are times when they need to do it. And looking ahead, unfortunately, in the immediate future, based on the increasing costs of everything, based on inflation that's applying to everything, in the years ahead, boards are going to have to increase their budgets, possibly substantially, just to maintain the same level of services that they're getting now. So the idea that there would be an inability on their part to raise the fees without having a majority of the community appear to say, yes, we want to pay more, is not workable. And it's putting those board members in what I think is going to be a really untenable situation. And it's doing so, or would do so if this bill passed, for no good reason, because as the sponsor just explained to you, mechanisms already exist. The communities in New Hampshire, based on the existing law, have the ability to override the board's budget. Yes, it's by a 2/3 majority, but that's the same standard that applies in most sets of condominium documents for other community decisions, including amendments to their documents. So it's not inappropriate to have that standard. In fact, I was here when it was being considered, and I said it then, and I'll say it again now. It's entirely appropriate that it takes a majority of the community to reject the board's budget, because it's the board that has the obligation to create the budget in the first place and has a fiduciary obligation to make that budget suitable for what they know the needs of the property to be. But again, if a board came up with an absolutely absurd budget, the community does have a means to act already. That's in place. So I also just want to mention briefly, because bankers were mentioned to you in the issue of associations getting bank loans. It is somewhat of a popular thing right now, because a lot of associations have not set aside the money that they should have over the past 20, 30 years for what are now major projects coming due. The lending industry has responded. They do offer products now, loans that are specifically geared towards condominiums. In New Hampshire, they have already adapted. Since 2016, when they found out that the community could, even by the 2/3, reject the board's budget, they changed the closing documents to protect themselves. And the bankers have told me that directly. There are now additional papers required that the board needs to sign, additional votes that need to happen and be documented, specifically because the banks are now being asked to lend money to associations whose communities next year could show up at the annual meeting and reject the board's budget. So even under existing law, the bankers have already had to take account the risk associated, and they've already done that. So I would submit to you that that's not really an issue here. So in closing, I would just like to say that the New Hampshire Legislative Action Committee of the Community Associations Institute opposes the bill. We oppose it for the reasons that I've stated, and we hope that you will leave the law as it currently stands. It is sufficient in this area, and again, in the immediate future, it's really what is needed more so than what's being proposed. That
Great.
concludes
Do
my
you accept
statement, but I'm
questions?
Absolutely. sure.
Representative Herbert.
Do condominiums get advised in terms of amortization of debt? In other words, do they put aside money for areas that might need work or predictable?
So a lot try to do that. I can't say that it's universally done, but there are engineers that are capable of providing specific reports. Some of these engineers, much like certain attorneys or accountants or other types of businesses, actually specialize in working with condominiums, and boards can get a study that tracks, what their needs will be in the future. The engineers that do a good job with this even project, the rising costs over time and things like that, so that associations, would be able to put the money aside. Unfortunately, all of the associations that are 20, 30 years old right now haven't necessarily done that to the extent they should, and that's why the bank loans are becoming popular for those who have to face major projects.
Thank you.
Yeah, Representative Bartlett.
Thank you, Mr. Chair. Thanks for coming before Commerce again, Mr. D'Addario.
You're welcome.
Have you had a chance to run this bill past any of the condo associations you represent?
Yes.
And what, could I just ask if,
Further question.
thank you, if you've had a sense of what some of them feel?
Certainly. If I were to summarize overwhelmingly, my clients feel that if changes like this are made to the law, that being on the board will be no place to be in the future. Because if you pass a budget that accounts for the financial needs of the association, but it involves an increase in the fee, and then the community shows up to say we're not paying it, then as a board member, you don't want to be there saddled with the responsibility of the consequences of what happens if the property isn't properly cared for. And so most board members that I'm hearing from would leave the post. And many of them have no idea who would step up under those circumstances to serve on these boards.
All set? Great, thank you very much.
Thank you.
Chair will call on Lou Gargiulo, who is also in opposition to the bill. Good morning.
Good morning, Mr. Chairman, and thank you for taking the time to hear my testimony.
Be sure to push the red button.
Okay. Thank you for taking the time to hear my testimony this morning. My name is Lou Gargiulo. I reside in Hampton Falls. I'm the CEO and founder of Great North Property Management in Exeter, New Hampshire. My firm is responsible for the management of more than 25,000 condominium and homeowner association units that house approximately 75,000 people. I'm here today to voice my strong opposition to HB 1146. As it currently stands, it is hard enough to get unit owners to run for the board positions. Many condos that I represent have unfilled board positions and have to beg people to stand as a board member. Owner apathy is a struggle, and participation sometimes is difficult. This bill will create an untenable situation from that perspective. It will make the ability to pass a budget much more complicated. But beyond that, it will have other implications. And they came to me as I sat here this morning. As an owner of a large management company, we are requested to provide information to lending institutions regarding reserve levels, regarding a whole array of different questions so a person can get a loan. The standards have increased since the tragedy at Surfside in Florida exponentially. Banks and mortgage companies are very hesitant to lend money to condominium associations. If a bill like this comes to fruition, not only will it create problems internally, it will make it virtually impossible for condominium owners to sell their units, because institutions will look at it and say the funding levels are not sufficient. As Attorney D'Addario said, there is an outcry when there is an increase in fees, but people have come to understand it, and frankly, they're going to have to understand it a lot more as time passes. The whole landscape of the condominium association from an operational perspective is changing, and all of it is now being pointed to Surfside in Florida. The situation there has caused people to relook at the construction, stability, and operation of community associations. And with that, the only way they prosper is if there is sufficient funding to maintain them. This bill will have a chilling effect on having that funding available. With that said, I ask you, the current law is more than sufficient. It gives the individuals involved in the association a voice. I think it was well crafted, and I see at this point no reason to change it. I ask you to find this bill inexpedient to legislate. Any questions?
I see none.
Good.
Thank you.
Thank you.
Tom Tesser? Good morning.
Good morning. My name's Tom Tessier, and I live in Nashua, New Hampshire at the Hayden Green Condominiums. I've served on 2 prior boards of condo associations, one in Hebron, New Hampshire, and one in Bridgewater, and now the one in Nashua. And I echo the sentiments of the 2 past speakers and their opposition. And our association board is in strong opposition of this bill for the same reasons that were just talked about, and I won't reiterate all of those items. But I can tell you, we are volunteers. There are 5 of us, and if we had to hire a management company to do the work for our association, it would be thousands of dollars in extra expense. And from what I've heard in our own association, we've been doing a great job. We have a good reserve. We've only had to raise our fees once from, believe it or not, $115 to $125. And I do recall that when we did that $10 increase, we did have some people who were strongly opposed to it, but we had to do it to keep up with the expenses of our association. If our volunteer board is restricted to what this bill is proposing, then I can tell you right now that the 5 of us would probably resign because we wouldn't want to take on the liabilities that would be facing us. And I don't know what would happen. I don't know if anybody would step up to serve on the board because we haven't been able in 7 years to get anyone to step up. And it comes up every year as the board seats rotate. Nobody's come up, so I don't think we would be able to get anybody to do that. We have 80 and 90-year-old residents in our community who don't come to meetings, don't want to come to meetings. Sometimes they vote, sometimes they don't. So it would be very, very difficult for us to maintain what we've done in the past, and we've done a good job. So we are in total opposition of this bill. Thank you for your time.
Fair enough. Thank you very much. Vincent Cervello? Cervello, all right.
Good morning. My name is Vincent Cervello. I'm from 335 Fox Run Road in Hudson, so I speak for myself as well as being the president of the Village of Barrett Hill Association. And I very much, like the other gentleman before me, am in opposition to this bill. It serves no purpose because the board per se has a difficult job in itself just to conduct business in a normal cycle to add anything more to that. You know, our board members are parsimonious and judicious in how we handle fees, and we don't have any assessments because in our monthly programs or monthly fees, we adjust for both the operating budget and the reserves to replace. And unfortunately, this year we've been faced with we're replacing decks at this association that's 30 years old, and we've got wood prices that have gone up 35 to 40% difficult to cope with. Snow plowing and landscaping have gone up from 15 to 30%. Unseen escalations in prices. You know, we have 5 board members, and we continually approach the community about providing more board members and volunteering and everything else. And unfortunately, the hard reality is that only a minuscule amount ever comes forth to provide those. The board is a representative governance of the association, and we try to do it always in the best interest of all the residents on an ongoing basis. So this bill should just be allowed to die quietly because it serves no purpose. So I thank you for listening to me.
Okay. Thank you. We got one more card left. Edward Colbert.
Hi, good morning. I live at Partridgeberry Hills. It's a condominium association in Nashua, New Hampshire. It's 304 units. It's a large property. I also serve as vice president of the board there. And we regularly have difficulty meeting the 33 1/3 quorum to just get the business of the annual meeting done. And sometimes we have to take 2 or 3 passes at that. That's the level of apathy. And that's really what we're all struggling with here is the apathy. So I believe owners do have a voice. And if the impacts of this bill would be very damaging to boards trying to get business done. If there's an emergency repair, they have to go out, and it's very, very hard to get participation from owners. In our association, about 70% of the condos are rented, so owners may not even be in this country very often. It's just difficult to get people on board. And I just strongly urge you all to consider it's already difficult for volunteers to provide good fiscal governance. I'm very lucky I've served on a board that's never had a special assessment in 40 years, but the property is 40 years old and it does need constant repair. And getting those things done is very difficult, and it would not serve any member of the association to have a board's hands tied here. So I do urge you to oppose this bill accordingly. Thank you very much.
Thank you. Having no more cards left, the overnight list, we have no support and 6 opposed. And the sign-in sheet, everybody is opposed, including, who didn't testify, Tom Arnold, Helen Hooker, and everybody else spoke. So with that, we will close the public hearing. All right, what's next? Okay, we'll open up the public hearing on House Bill 1380 and hear from the prime sponsor, Representative Van Houten. Good morning, Representative Van Houten, and welcome back. Mike, yeah, you got to push the red button. There you
I
go.
pushed the reverse, I apologize.
Yeah, no problem.
So for the record, I am Connie Van Houten, New Hampshire State Representative from Hillsborough District 45. 45 spans the 3 wards on the west side of Manchester. The northernmost ward where I live borders on Hooksett, and many condominium and homeowners associations have been developed there. For the clerk, I do have written testimony that I will get to you afterward, although I will deviate from it perhaps. I'd like to begin differently than I had planned. I think perhaps we need to do some definitions. The people behind me who have spoken on behalf of condominiums and condominium associations are different than the people that would be referenced in this bill. Condominiums and condominium associations are different from homeowners associations in a couple of basic ways. Perhaps the most basic way is that the condominium owner owns an individual unit. I am a condominium owner. I own a unit. I don't own a building, a freestanding building. I don't own any lawn. I don't own any of those types of things. I am a member of the Communities Association, though, and I share an ownership stake in what the association owns. Now, the Homeowners Association, which is the subject of the bill before us today, is different. Each owner owns an individual property, perhaps an individual lot as well. So for the most part, when we talk about a homeowners association, we are talking about freestanding units. In both types of associations, both types of communities, there are shared and common interests, and those will be impactful as we talk about the bill here. So to return to my comments, I'm here today to introduce House Bill 1380 on behalf of constituents who, as I said, are my neighbors, and other New Hampshire citizens. Many of them contacted me after a 2020 House bill passed by this committee was passed by the House on a voice vote, and then, of course, COVID reared its head, and the Senate laid the bill on the table. The bill before you today is identical to that bill. HB 1380 prohibits homeowners association deeds or other instruments pertaining to conveyance of real property or interest therein, from prohibiting or restricting the installation and use of solar photovoltaic energy systems. The bill makes any portion of a deed or other legal instrument that prohibits or places unreasonable limits on the installation or use of solar void and unenforceable. In essence, installation or use of solar systems would no longer be subject to terms of the governing documents of the homeowners associations under this bill. This bill does not require that such documents be rewritten, however, and it is not a mandate. Instead, HB 1380 puts the decision about solar into the hands of the owner of the unit, rather than by permission of others, such as the board of directors. Currently, though, it would be possible for an association on an individual basis to grant some requests for solar installation and use and not others, thereby even changing the physical uniformity of the association that many people cherish as well. I do realize that there are objections to a bill of this sort. Part of that has to do with the fact that condo and homeowners law is relatively young in the scheme of things. I do understand and am respectful of those differences and those concerns. However, in bringing this bill forward on behalf of constituents and other New Hampshire residents, I am honoring their concerns about increasing costs of energy and the ramifications of those increasing costs, and the need for clean and renewable energy and expansion of its use. Some association documents have existed for decades, and more New Hampshire citizens and residents have gravitated to ownership and living in communities of homeowners associations since those documents were written. But the landscape of our current world, colored by topics like inflation, supply chain issues, and climate concerns, mentioned in everyday news, has changed. This legislation is not without precedent. For example, the California Solar Rights Act prevents homeowners associations. Excuse me, these masks are difficult to breathe through sometimes. The California Solar Rights Act prevents HOAs or homeowners associations from limiting a person's ability to install solar panels, as do more than 24 other states. If this were to pass, solar installation would still be subject to local ordinances, zoning regulation, permitting, and inspection, and would not intrude upon common or limited common elements of the association. Again, that's because in a homeowners association, the owner owns the building as well as probably the lot. The bill, however, would allow an owner or owners of a unit under their control to make choices about their energy systems and cost of energy. I'd like to close by just highlighting 3 of the misconceptions that exist, partially because of the interchangeable use of the words condo and homeowners association. First of all, homeowner associations are not condos. The property is controlled by the owner, and therefore this bill would talk about installation on that property, not on common areas. So if I were in a homeowners association and owned my own building and controlled my roof, took care of the repairs for my roof, and other ways had control of my roof, I could put my solar panels there. That would not be considered common property. Also, this is not a mandate. It is actually almost the reverse of a mandate. It's lifting a requirement that exists in some homeowners association documents, the requirement being that solar panels cannot be used. And therefore, there would be a freeing of the ability of the homeowner who owns the building to use solar panels if he or she wished, sorry. And finally, the documents. Documents, as you've heard from people behind me talking about condominiums, are critical to the running and operation of any kind of a community organization like this. Those documents would not become void and unenforceable. The only thing that this bill, as it's written and as the other 24 plus bills are written, would do is to make sections or portions that talk about solar panels void and unenforceable. The documents would not need to be rewritten. The documents would stand. However, there would be aspects that were unenforceable. That is also what we see in other legislation throughout the country. So thank you very much for allowing me to present this. It is a passion of many of my constituents to have solar for many reasons related to economy, related to clean air, related to the ability to exist in a home in which they will be happy and comfortable for many years. I'll take questions. Thank you very much.
Questions? Representative Abel.
Yes, welcome back. We're
Thank
so
you.
happy to see you.
Good to see you, thank you.
Would you believe that I live in a homeowners association which are all involve individual structures, and in which there are some houses that have solar panels and some do not, and this has existed for a long time. And I just want, but that's my first question. I have a second question.
Absolutely, although we talk about uniformity when we talk about homeowners associations, by virtue even of topography, things are different. Some people are not oriented to be able to harness solar, for instance, and would not be interested in it. Some people live on hills and the driveways are configured differently. So although there is a great deal of uniformity, there doesn't exist total uniformity, and apparently your homeowners association is elected to allow solar to be part of that change from uniformity.
And may I
Further
ask-
question?
Yes, thank you. My question involves whether the solar panels would be on the roof of a building or could be on the ground.
I think there are probably 4 or 5 different placements that have worked in homeowners associations that have used this bill to get solar energy for them. The bill specifies that common areas cannot be used for placement. And so the condo docs, not the condo docs, I'm sorry, the association docs, the documents that go with the homeowners association will play a role here. If, for instance, you have a unit, it's an individual freestanding unit, and the roof is controlled totally by you, you could put your panels there. If the lot is also controlled totally by you, you could put your panels there. If, however, according to the documents for the association, they are association maintained or association managed, and you do not pay, for instance, for roof repairs, then you could not put them there. The common areas element gets a little bit murky because there are things like limited common areas and true common areas. But as crafted, this bill only allows you to put, you as a homeowners association member, allows you to put these panels in places that you are in control of. And the roof or the lawn, if that were the case by documents, could be those places.
Okay. Other questions? Yes, Representative Greason.
Thank you, Mr. Chair. And thank you, Representative, for taking our questions. What is the definition of significantly as it pertains to significantly increasing the cost or expense or significantly decreasing the efficiency, and who determines whether it's significant?
Well, that would again be a board thing. A lot of these elements with homeowners associations, as I said, are run by documents and boards, and so the board of directors would probably assume that. Let's say that they wanted to be sure that maybe they would ask you to only put your panels in a certain area of the property, and perhaps that area of the property does not get enough solar interaction to harness as energy. That would probably significantly reduce that. However, as I think with most things, particularly with condo and homeowners association law being as young as it is, I think some of these things are evolving as we go. And some of them, as we've heard from people behind me, with whom I agree on a lot of issues, but some of them are up to the board of directors or volunteer group who do their very best to manage the associations that they deal with and to come up with the right answers. And some of the things we've talked about previously involve mechanisms to make sure that those best interests are maintained. So to answer your question, I'm not sure 100%, but it would be within the homeowners association themselves to work those types of things out. But seriously, if someone told me that I could put my solar panels only inside my garage, I would have a concern.
Yeah, I guess that's where my question would aim at. And that is, given that we don't single-family homes, and I know homeowners associations can, for whatever reasons they want to call it that, but for the discussion purposes, we're talking about people who own their own house in a standalone, separate building. Do you actually have a story or an anecdotal story where somebody wanted to put photovoltaics on their building and went to their homeowners association and they And the homeowner association said no?
Yes. And that was the genesis of my reintroducing this bill, which was also in the last session. The woman has currently moved, but a psychiatrist. I do live in a condo association, but just above me is a homeowners association. And she had a marvelous home, very nice and very well appointed. And she did request solar from her condo association. They did put it to a vote. That was their means of dealing with the issue. And she came armed with a lot of information. She just sold her freestanding condo for $500,000. But she was also told that could easily have been $100,000 more. She also gave me some figures that showed that she could have recouped the cost of her equipment, her installation equipment, in 7 or 8 years. This is 03102, so it's near Hooksett. And that at the end of that 7-year period, she would have paid off the installation costs, begun savings, and then being able to hopefully return some of that energy under a net metering relationship. But she was denied. Since then...
The neighbors decided they didn't want her to do that.
Right. And what they were citing was the aesthetic element. I understand that. I understand that people buy condominiums and homeowners association buildings because they do agree with the aesthetic. As I've said, again, I don't want to mix things up here, but I do live in a condominium. I have previously owned another condominium. I've served on boards of directors.
But we're talking about homeowners associations.
No, I'm coming to a point. When I bought my condo, there were many, many things that I could check off my list for. There were a few things that I totally didn't like. And so I had to accept that uniformity was not going to totally happen. I have some incredible pillars that I understand they're thematically appropriate, but they've always bothered me. It didn't stop me from buying the condo association. So uniformity, and by the way, other units don't have those pillars. I sometimes wonder why me? Why do I end up with these pillars? But the uniformity aspect, it's important. The aesthetic element is important. But we're talking here about energy savings. We're talking here about clean energy. We're talking about the futures of the condominium and as homeowners associations. I heard a report driving in this morning that gas prices are likely to hit $4 a gallon in the very near future. Energy costs, energy uses are important to us, especially in a world that has changed so drastically in the last few years.
Okay. Thank you very much.
Thank you.
Okay, so similar to the last bill, we have nobody else in support, so we'll just go through the opposition, and we'll start out with the Community Association Institute with Gary DiDaprio. Why don't you start out, Gary, and why you are in opposition to this bill?
Good morning again, and thank you again for allowing me some time. For the record, my name is Gary DiDaprio. I'm here in my capacity as the chair of the New Hampshire Legislative Action Committee of the Community Associations Institute, and I practice community association law here in New Hampshire. That's the sole focus of my practice. So I'll begin with some of the actual language of the bill. It starts out by saying that any covenant, condition, or restriction contained in any deed, contract, mortgage, security, instrument, or other instrument, to the extent that they unreasonably restrict one's ability to install solar, shall be void and unenforceable. So that's really pretty broad. Actually, I want to, excuse me and pardon me, I just want to take a quick step back. We are not, to be clear, both as a group and myself personally, we're not against the idea of solar or against the idea of clean energy. We're just not. I myself had solar installed at the last house that I lived in, but I was not within an association, and there weren't any documents or restrictions that I was supposed to abide by. I wanted to make that much clear. Getting back to the language of the bill, what I just read was very broad. These documents, deeds and contracts, mortgages, security instruments, they all already exist. And there are a lot of folks out there who I think we should consider and who presumably wanted to get the benefit of their bargain. I understand that homeowners associations are different than condominiums, but I represent homeowners associations as well. And what they have in common is that, like condominiums, they exist in part because of their documents. Their documents create these neighborhoods. They lay out the terms and conditions by which they're supposed to operate and the restrictions that presumably all of those who voluntarily agree to buy into that association are willing to live by. And so I think they really need to be allowed to go ahead and do that, to live within the confines of the governing documents that created them, and that everyone who's become a member in the meantime had an opportunity to review and presumably agree to live by. Those owners who bought on the basis of restrictions, and these people exist, I've spoken to them. For some, they really have a primary interest and a primary focus on living in a community that has a very set appearance, including all the consistency and everything looking the same, the way they do in condominiums and associations. And I don't see why we should deprive those folks of the benefit of the bargain. If they found an association whose documents had restrictions that they wanted, some folks have bought into the association because they wanted to live around people with those restrictions. And that having been said, it's also important to note that those restrictions can change internally. The state doesn't need to override and overrule all of these documents and say that they're unenforceable and say what associations can and can't do, because they have that power already through the amendment process. So in any association that for whatever reason has documents that would be overly restrictive of solar right now, to the extent that a majority of that community decided that they wanted solar, they would simply vote to amend the documents and make the necessary changes and adopt solar. And I think that we should let communities do it that way. Because again, otherwise, what we would really have is the state imposing changes and invalidating documents that already exist, that people feel that they should be living by, and that courts would enforce as covenants running with the land. My last comments would be this, based on what the bill sponsor said. To the extent that this is intended to apply to homeowners associations and not to condominiums, I think that easily enough a provision could be inserted that explicitly states that it doesn't apply to condominiums. I think without that, there would certainly be those folks who would argue that perhaps it does, especially since it's being inserted into 477, which is more of a general real estate section of the RSAs. My next comment about if the bill was to move forward by way of recommendation, again, we heard from the bill sponsor that the bill is not meant to allow owners to put solar equipment in places that they don't control. In other words, the common areas of an association, which no owner has a right to exercise dominion over. To that end, I know that that's the word that's used in the statute, areas controlled by such an owner. But in my experience, whether we're talking about condominiums or associations, the documents generally don't speak in terms of control. It's more about ownership. Owners own their unit, or in the case of a homeowner association, they may own the home itself, the whole freestanding. But they typically don't own other areas. In any event, my suggestion is to replace the term controlled because it could cause potential confusion with areas that are solely owned by the unit owner in question. And I think that would at least, if this bill were to go forward, I think that would at least prevent some confusion and some arguments that might otherwise occur over where things might be placed. Thank you for your time.
Representative Herbert has a question.
So am I correct in what you said? Am I correct in assuming that, say, technology changes or whatever occurs in the future? Nat gas goes to $100 a pint, you know. The existing law allows for a democratic vote of the association, and that can change the, so the state legislature is not needed, a new law, outside of what your recommendation is. We already have the ability as a homeowners association to update and, if we so wish.
Correct. That's actually, I would suggest, an excellent way to describe the situation, that this bill isn't needed because if a community wanted to allow for solar, they could do that through the document amendment process that already exists that would be based on a vote of that community. And by the way, the reason why that's a lot more fair is that when people accept deeds to properties that are in condominiums or associations, one of the provisions states not only that they're taking ownership of the property subject to those documents, but standard language also says that they're taking the property subject to any amendments to those documents. And so that if that community should vote to so amend their documents, technically speaking, those owners, all of them, even the ones that didn't want to see, you know, a solar panel perhaps, all of them have agreed to live by those documents if they're amended as well. But again, the amendment that's contemplated is by the community, you know, not by the force of the state.
Great. Thank you very much.
Thank you.
Chair will call on Lou Gargiulo. Good morning again.
Good morning, Mr. Chairman and members. Thank you for allowing me to speak. Again, my name is Lou Gargiulo from Hampton Falls.
Yeah, Mike, yeah, sorry.
I'm the CEO and founder of Great North Property Management, who manages approximately 25,000 condominium and homeowners association units. I'm here today, although I support clean energy options and I believe in them, I'm here today to voice my strong objection to House Bill 1380. I'm doing so for the following reasons, and much of which is reiterating what Attorney Daddario said. Many people buy into HOAs, homeowner associations, because they enjoy clean and cohesive atmosphere in a neighborhood governed by established association documentations and rules and regulations that they understood when they acquired the property. In this particular bill, essentially, those restrictions, those deeds are all going to be upended in an effort to allow something that the members did not bargain for when they acquired the property. As Attorney Daddario said, the resolution in an association is very simple. You amend the documents to allow it. And if an association wants it, and if the majority of unit owners want it, then you amend it. You cannot allow the minority of one person or two people to control the majority. It's not fair, it's not appropriate. So with that said, I'm not going to prolong your agony. I ask you to find this inexpedient to legislate. I think it's bad public policy to try to insert yourself into something that already exists in statute and in law. So have a great day.
Great, thank you very much. Chair will call on, let me get the right bill here, make sure I didn't, all right, Vincent Cervello, again. Morning again.
Good morning again. Since the issues and the salient points have already been outlined, there's no need for me to say anything further. And I also favor clean energy and efficient energy where we can secure it. But you know, the fact that heating oil and gasoline have gone up from, gasoline in particular, from $1.50 to now $3.50 is purely and simply the function of bad policy in Washington. And it's incumbent, I think, on people to really push back on those types of adjudications that cause that kind of escalation, because otherwise we have plenty of fossil fuel in this country. Thank you so much.
Okay, thank you. Tom Tessier?
Morning, again.
Good morning again.
Speaking for myself and my wife and the board of directors of my association, I am speaking in total opposition of this bill. I don't see why the state should mandate something that we can already do and that's already been approved. I don't understand that. And with all due respect, New Hampshire is not California. I would hate to see that happen. We own our own building and we could put solar panels on our roof. My wife personally thinks they are hideous and ugly, but someday, and I've read something about some company was trying to develop roof shingles that would actually act as solar panels. If that happened, maybe our association would change and amend our documents and allow it. Another example that would be comparable to what my wife says about solar panels is we did have one unit member put up pink flamingos on her lawn. We didn't have any documents or amendments that said that she couldn't do that, but when her neighbors saw it, they were down in less than a week. And we've since made provisions for that not to happen again. We control our association. We have votes. It's a democratic process. It's working great. I would think 99.999% of the time. So I really don't understand why this should be mandated, and we are in total opposition, and I thank you for your time.
Okay, thank you. We have a lot of pink flamingos in our area because we're very close to Lunenburg, Leominster, where they're all made in America. So everybody seems to have one of those. Helen Hooker?
Hello, my name is Helen Hoker. I wrote
A little bit closer to the mic. Yeah.
I wrote an email pretty well stating my opinion. I am president of the Condo Association at White Rock and Bow. And one thing that has continually gone through my mind is I am quite surprised that these two bills even were introduced into and got as far as they have gotten on what is basically internal matters within individual condo associations, to which people buy into voluntarily, are not asked to stay if they choose not to like what's going on. They have voices. They can oppose anything, but they are asked to live within what they bought into, which I have them sign off on. When they come, they are presented with the rules and regulations and the condo docs. They are asked to sign a paper saying that they have read and accept those rules and regulations. And it is by far not necessary for a state to come in and even suggest that these rules and regulations to which they have agreed to can be overridden. That's what I have to say. Thank you.
Fair enough. Thank you very much. All right, having no more cards. The overnight, we have 6 supporters and 8 in opposition. And in the committee room, pretty much everybody spoke, so I won't bother reading their names. And with that, we'll close the public hearing on 1380. Okay. I'm waiting for my clerk to be prepared and ready. I'm not ready yet. Okay, don't worry. You'll be out of here by lunchtime. Don't worry. Okay. Well, I would hope not. You want to make sure your bill gets a thorough hearing, don't you? Okay. At least he's honest. Okay. We'll open up the public hearing on 1378, and he's got his microphone on, so good morning, Representative Ullery.
Thank you. For the record, my name is Jordan Ullery, Representative Hillsborough 37, and I'm introducing House Bill 1378 relative to the inspection of public lodging houses. This is a very simple bill. It places no burden not already placed on the business to maintain records. All it does is say that these records need to be available on the presentation of a warrant. Our local chief of police and several of the other surrounding towns that have a lot larger number of motels routinely get a warrant for this type of information. It's a matter of privacy. If you remember back a few years ago, we passed out of the General Court an amendment to the Constitution that was put on the ballot. It's one of the few constitutional amendments that was actually passed by an overwhelming number of individuals or persons when it was put on the ballot. That is a right to privacy. We each have, in New Hampshire, enshrined in our Constitution, a right to privacy. Now, the extent of that privacy can be limited in certain cases. We don't have a right to privately kill someone, but we have the right to general privacy in our daily activities. And if we want to, what's that? Actually, something, well, there's the website that's out there that allows you to hook up. Fine. You know, that's a choice that you made, and the other person hopefully was doing it consensually. So that's perfectly fine. It's not fine, but it's none of the sheriff's interest as to who's in that particular room and what their names are on a general search. Just a broad blanket search of what's going on, which is what current law allows. The sheriff or police officer, or I would assume, even though they're not mentioned because the state police didn't exist in, what was it, 1923? When the bill was first, or when this law was first put into effect. So, it's a really simple bill. All we're doing is saying, yeah, have to have a warrant to which probable cause has been attested, which warrants have, that's part of a warrant at any rate. This is a constituent-driven bill. The constituent is here. He has testimony that he would like to give. That's Mr. Khan. And regarding his family's own experience, which is disturbing. But the rule of law is to control government. This helps control government. Now, I will admit that the entire chapter needs to be updated in some fashion.
Yeah.
And I'm open to some amendments, but the law itself needs to be present for a wide variety of reasons, not the least of which is I had presented a bill to transportation many years ago to allow for the safety inspection of trucks, which has already uncovered some men coming down for labor, illegal labor, and women who were coming down here for the sex trade. That was several years ago. That's just a safety inspection that was allowed of New Hampshire registered vehicles, but now it can be applied across the board as a safety inspection. So anyone who goes through the toll or the weigh stations can may be subject to that. Human trafficking is despicable, and there needs to be some method of controlling that. But I think Merely asking for a warrant doesn't get into that. The fact is that if I go to a motel, I'm expecting some privacy in being in that hotel while I'm there, and not having the local gendarmerie come in and just, and I know they don't, and I know this is going to sound bad, but they can right now just go through the card and see who's there. And for what, you know, that's just all, just to see who's there. May have been appropriate in the 1970s, isn't appropriate today. That's the essence of the bill. I'd be happy to work with the committee if further additions or modifications of this particular chapter need to be taken. Are there any questions, Mr. Chair?
Evidently we do. Representative Burrows is first.
Yes, thank you for taking my question. And this is a would you believe and what do you think scenario. This is a real story in my community. We had a murder in an Army-Navy store. There were SWAT teams all over the place. So in that scenario, when their time is of the essence, the whole town was in lockdown. We were terrified of what had happened. How would this bill impact it if let's say, they thought that this person was staying in a certain lodging facility? How would that impact the timing of them going in to check that?
Under current law, and I'm sure the sheriff or the attorney general will correct me, but under current law, if you cannot search a house without a warrant, unless, and it's the unless that is the important thing. Exigent circumstances can be abused, but they're not to a large part, and if they are, then they're going to get the entire case is thrown out. Fruit of the poisonous tree, I think, is the terminology that's used. So it doesn't have an effect, in my view, on that, because exigent circumstances would allow access to information based upon the life of a person or impending harm to a person, in the same fashion that a non-law enforcement person can use a firearm to defend themselves or others.
Follow-up, should that be in the bill, though, to specify that?
I don't think so. I will leave that to the attorneys to give some extra oomph to it.
Thank
but
you.
I don't think so. It's not in the law for search warrants. But if you hear somebody screaming inside a building, you can break into that house.
Thank you.
Representative Bartlett. Okay, any other questions? So I guess I have a real problem with the statute. But we'll start out with, do you know any hotel today that has a book or a card system for guests to sign in to?
Well, it depends on what you mean by book.
Well, that's
or
what the
card
statute
system.
says.
Yeah, well, when was the statute written, sir?
Evidently, you just told us, 1923.
And when was it last modified?
I have no idea.
I'll leave that to the Attorney General's office, but I think it was 70, 73, something like that. But actually, if you take a look at the sign-in, when you go to a motel, you're signing into a card system. You're using your card to get into the place. I suppose that would be a justification. You're correct, sir. Some modification needs to be made.
Right. Well, yeah, but even, and I said, oh, well, I had put my credit card to, for incidentals. It might not be my card. It could be somebody else's card. It could be my parents paid for me ahead of time. So that's not telling you anything other than you have another name. That would be illegal. You can't, the hotel would be in violation if they were using that as the name.
I think most hotels are in violation today.
Perfect. Representative Johnson.
Thank you for taking my question. Would this apply, because the way I'm reading it, that their book or their card system is now pretty much electronic? Because I know when you go into a hotel, you need a picture ID, or you cannot rent a room.
Yeah, the conferences that I go to in different states and even here in the state with the Knights of Columbus, when you go in, or when you make your reservation, you give them the card information that's going to secure the room. And then when you show up, does that information match the card information? Is the routine procedure. Now, do we need to put that into law? Or do we need to modify this particular chapter in some manner so that it reflects current business practices and business practices into the future? So the language would be open-ended, that verification of identity upon blah would be an appropriate.
Further question, you may inquire.
Is it my understanding is that we already have laws that say that you cannot stay in a room without proper ID.
I'm not aware of that. I think that's more of a business activity. Because
Would
they
you
want to-
believe I've already ran into this issue? We tried to rent a room for a relative in town. They didn't have ID. They would not rent the room, even though we were paying for it. She had no ID, so she could not get a room. So she drove home that night. Would you believe?
Would you believe?
I'm famous for those.
Okay. Yeah, I obviously, the only other question I have is, I have a vacation rental. And when I read this definition of lodging house, it somewhat implies that if I have 2 or more rooms that are habitually, and I don't know what habitual means, but if I rent out my property enough, that means I have to have signatures from these people who booked online and through Airbnb, Vrbo. I don't have any of that.
Well, as I said, Mr. Chair, open-ended language that would allow this to go forward into the future for many decades, as this bill has set in the back corner for many decades, would be appropriate. Now, banning it all outright, I will disagree with the constituent that brought this forward for the reasons that he will explain. But open-ended language, I think, can replace the first sentence very, very easily. Maintain a record, verify identity, that kind of language would allow future record keeping in whatever manner happens to be the most efficient for the business, as well as give law enforcement the needed access to the information. I do think that if law enforcement's going to go in and rummage through the records of who's sleeping in which hotel or cabin or whatever, they probably should have a reason for doing that rather than not have a reason.
Fair enough. Thank you very much.
Thank you.
All right, we'll call on Richard Kahn, who is the constituent who has a real-life story here. Good morning.
Good morning. Thank you, ladies and gentlemen of this committee. My name is Richard Kahn. I live in Hudson, New Hampshire. I'm going to cover 3 main points. Number 1, the civil liberties issue. Number 2, possible law enforcement point of view. And number 3, what makes it personal for me. Before Representative Ullery agreed to submit this bill on my behalf, he says, I need you to talk to Chief Avery. Bill Avery is the chief of police in my hometown of Hudson, New Hampshire. The first thing Chief Avery said to me was, I wasn't aware that there was this law allowing law enforcement to see the hotel registration log, whether it's cards or computers, doesn't matter, on demand. Okay, he says when he has to go, I think Hudson has like 2 hotels in it, and he says when he has to search a business, hotel or otherwise, his words, not mine, that he likes to get a warrant because, and the prosecutors in court appreciate that because it makes their case in court stronger. That's his words, okay? He said also that he would check with somebody, I don't know who he spoke with, in the Attorney General's office to see what the compelling law enforcement interest in it was, and he wasn't able to find out as far as I can tell. Okay? Number two is the civil liberties issue. Police should always need a warrant to search any business or private property. I heard it mentioned that there's always, well, what if there's something really bad that happened and they have reason to believe there are suspects in this hotel? Well, exigent circumstances, I heard that already mentioned. Now, the third point, which is the one that makes it personal to me, is where my family came from, especially on my dad's side. Now, I know a lot of people compare, when they don't like something and they want to make a point, they compare it to the Nazis. Well, my father was born and raised in what became Nazi Germany. I used to ask him and my late Uncle Walter, when were you first aware you had to leave the country? And I am going to tie this back to this bill. For them, the defining moment was 1936. My dad was in some kind of children's camp, and he remembers seeing signs around Germany, Juden unerwünscht, meaning Jews not welcome. My Uncle Walter, when he remembers in July of 1936, riding in the back seat of the car with my grandparents. Somehow, my grandparents got word that German soldiers had come to the hotel they were staying at, asking if there were any Jews staying there. Grandma looks at Grandpa and says, we need to go, as in leave the country. Took about 2 years to get their affairs in order to make the transition to this country. So picture somebody coming in, and if you don't think it can happen in this country, well, maybe there is a Santa Claus. But basically, somebody coming in a uniform, wanting to see the hotel registration log, whether it's paper or computer. Let's see, Einstein, Goldberg, Kahn. Those sound like Jewish names. Well, by the way, my father, still alive. He served in the U.S. Navy in World War II. He's 95 years old, so unfortunately he could not be here to confirm this, but he said that it wasn't German soldiers that had come to the hotel, it was the SS. In other words, Hitler's private army. Okay? My interest in this bill is wanting to make sure that we are not going to fall into that trap. Well, trusting the law enforcement to use the proper restraint and getting the warrant unless they really have exigent circumstances, I'd like a little bit more reassurance. And with that, I'm done. I'll take any questions.
Okay. Thank you for a very compelling story.
Thank you for your time.
The chair will call on Michael Thornton.
Thank you, Chair, Representatives. Michael Thornton, Milford, New Hampshire, speaking as an individual. Support HB 1378. Will submit this testimony in writing. Because of the experiences of Sergeant First Class Clarence E. Thornton, who was wounded on 20 December 1944 and captured soon thereafter during what became the Battle of the Bulge. He was illegally leased as a slave by the camp commandant. He was lucky. His new owners were candy store owners, an elderly couple under the protection of the camp commandant. They insisted he drink a cup of warm liquid candy base each day. After all, a slave who can't work is worthless. Thanks to their kindness,
you have this testimony today. The sergeant saw the horrors of that war, the internment of his fellow soldiers, and of the adjacent camp for Juden. There were no Geneva rights accorded. He was finally liberated 26 March 1945. After the war ended, he was assigned as an intelligence officer in Germany. He loved the German people with cause. He hated the Nazis with cause. The cry of papers. They said it happened so slowly, and then it happened so fast. You want to travel? Papers. You want lodging? Papers. This is America. This must not happen here. We already have real ID. We have mandates. We have talk of vaccine passports. Papers. This is just a slight inconvenience. It's all for the common good. Papers. One small step at a time. Innkeeper. May we see your guest registry, please? Just such a slight inconvenience. Please limit this invasion of privacy. Please require a search warrant issued only under probable cause. Sergeant Thornton would thank you. Please support HB 1378.
Would you be willing to take questions? Yeah, Representative Terry.
Yes, sir. Thank you for your testimony. For all those who would say, or rather, no doubt, will say, this could never happen here, or this is different, how would you respond?
It is happening here. Representative, thank you. Every day we see additional laws. It is said currently that an American citizen doing their very best cannot help but infringe on an existing law already. We are already asked for picture ID at the grocery store, at the drive-thru, to vote, everywhere we go. It is a creep. We do, under Article 3, surrender some of our rights to the common good. Not, what is it? It's not defined, not half your rights, not most of your rights, some. We risk going too far.
Further question, you may inquire.
Following, just to clarify, do you believe that what you're observing and informed by your life experience may very well be impinging upon our unalienable rights to life, liberty, and the pursuit of happiness, rather than the common good?
It does not currently prohibit. It does slow. If you've gone swimming and you're walking back to your beach house and you're asked by an officer, could I see your ID, please? It's difficult to produce. Officer, it's right over there in the room. Will you come with me? If you walk out of the house without your wallet, you don't see the sign and make a left turn where it's prohibited, and you don't have your identification. The science fiction author Robert A. Heinlein said, when you can't live your life without constant ID, it's time to move. We are not there yet. We are getting there more each day.
Representative McAleer.
Thank you, Chairman. What would your opinion be on a voter ID in order to vote? Is that impinging?
In that case, if we look at the community's right to have a fair...
Point of order, please, Mr. Chairman. I'm wondering what producing an ID, a voter to vote, has to do with this particular bill.
The witness
which
brought
has
it
to
up.
do with a warrant for probable cause.
I just want to
Could
get
you
to the hearing.
clarify that for me, please?
He took liberties
Okay,
with his testimony, and so we're just playing it out.
because he opened the door. Okay, thank you.
Certainly, and I welcome the question. A fair and honest election in a republic, a democracy, quasi-democracy, is essential. The identification for that is minimal. It is free for the asking. You're supposed to have proof of residence. That is your responsibility, which you accept freely as a citizen and if you wish to vote. It is not forced upon you. That, representatives, is I feel the difference.
Representative Herbert was next, and then Representative Bartlett.
Do you believe that everybody knows they give a lot of information away when they're on the internet? So I'm curious as to where you think that category of information sharing would fit in this discussion.
It is similar to a published book which is circulating after the copyright has expired. It is in the open domain. You have released that information voluntarily. You've given it up, and you've done so under the internet conditionally. You haven't. You have the option to say, "Don't sell my information. Don't publish who I am, where I am, and what I've purchased." That's the determination.
Well, we have a bill that does that tomorrow, so come on by. Representative Bartlett, did you have a question?
Thank you, Mr. Chair. So you're feeling that we have to show ID in many different ways, and then you've also made the statement that we live in a quasi-democracy. Would you please expound on that?
Yes. Thank you, Representative Bartlett. The definition of a true democracy, I was reading on an article, I'm sorry I can't remember specifically where, but it listed America as a failed democracy. We are not a true democracy, we're a republic.
I'm sorry, I'm going to interrupt you. If you can't remember where it came from, I feel like that's hearsay.
Okay, well, thank you. Say it a different way. High school civics. We are not a pure democracy under our founding documents. We are formed as, quote, a republic if they can keep it. We have guaranteed rights that originated from our maker, so-called natural rights. We voluntarily give up some to participate in our community. We give up others in a daily basis, incidentally, to do commerce. When we vote here in New Hampshire, it is entirely different from other places I lived. Ohio, Massachusetts, California. If you did not register 30 days prior and did not produce ID, you could not vote, period. We are extremely free and forgiving state. It would be wonderful if we could keep that.
Great. On that note, thank you very much. So I have two cards left. Mike Summers from New Hampshire Lodging and Restaurant Association takes no position on the bill, but like to speak to us for 2 minutes.
Thank you, Mr. Chairman.
Close to the mic.
Yes. Can you hear me? Sorry.
Yeah.
For the record, Mike Summers, New Hampshire President and CEO of New Hampshire Lodging and Restaurant Association. We aren't really taking a position on the bill as written. Frankly, we would leave it to you all as our policy leaders, makers, to determine how this should play out. But since this bill opens the door in this section of the statute, we have another concern, which Chairman Hunt actually alluded to earlier, which is the section that refers to shall keep a book or card system, cause each guest to sign therein his own legal name or name by which he is commonly known, said book or card system, etc. Frankly, in today's day and age, hotel commerce, you guys already kind of discussed this, with the pandemic and contactless payment, contactless check-in. In some hotels, in some states, you don't even go to the front desk or talk to anybody. You essentially get your check-in in your phone, you run up to the door, you tap the door pops open. So ultimately, we'd like to see that kind of removed. And to Representative Ullery's testimony earlier, this section of the statute hasn't been updated since 1973. So I think it's time that we did something. We don't necessarily have a clear recommendation of what that should be, but we're certainly happy to work with the committee to figure out what that might look like. One of the questions that was asked or statements made earlier about having an ID to rent, that is more of a business decision than required by statute in the state of New Hampshire. But that business decision is really, it stems from the fact that you don't necessarily want to be tricked into allowing somebody to rent who's using false identification or no identification, false credit cards, so identity theft and those kinds of scenarios. So I don't believe anywhere in statute it's required in New Hampshire, but most businesses do require it as a protection of the business. And since we're here and going through all the old statutes, I thought I'd throw a couple other options on the table for you. Also within Section 353, Section 3A, posting of rental rates, requires that you have your minimum and maximum room rates posted inside the hotel room. That was last updated in 1979. And frankly, I think most hotels in the state are in violation of that part of the statute as well, simply because the rates change almost daily at this point. It's all online. We've all seen it. So it becomes kind of a moot point. The other section I would throw out there is 353.5, which is under signs, hasn't been updated since 1959, which also requires that if you are going to post the room rate outside on the side of the road, you have to have your minimum and maximum prices, and it has to be of a size that can be read by the traveling public. So again, if you're going to open the can of worms, we're going to go all in on this. So I thought I would offer those to the committee for consideration. I'm certainly happy to try to answer any questions you may have, but it's here. We figured we would ask.
So is there anything in the actual RSA 353 that you would think we should keep, or should we just repeal the whole thing?
I think there are some sections we should keep, yes. I could read the list if you like, but
we'll look at it.
Save that for another day, yes.
Okay, Representative Below.
Thank you, Mr. Chair. Thank you for taking my question. You represent the Restaurant and Lodging Association. Were there
A little closer to the mic.
Were there specific hotels or bed and breakfast owners that phoned you about
actually,
this bill, in regards to this bill?
Yes, thank you for the question, Representative. So yes, I have been contacted by a few members, and again, this is kind of a side effect of the pandemic, frankly. But we do have some facilities that are either have switched over to or in the process of switching over to that contactless check-in payment system. So they found themselves in a bit of a conundrum about, well, if they don't actually come to the front desk and talk to anybody, how do I get them to sign something? Because we're of adopted technologies in order to deliberately avoid that transaction ed scenario. So I did get a few property owners that had called me and asked questions about that. Unfortunately, when we'd had these conversations in the fall, we'd already missed filing deadlines, so we didn't really take it up. But when we found this bill had been conveniently filed, we thought we would jump in on the coattails, so to speak.
Representative Greason.
Thank you, Mr. Chairman, and thank you, sir, for taking our questions.
A little closer to the mic.
Sorry, yeah. So aside from all of the out-of-date language of the overall section, this bill specifically has bolded that law enforcement would require a warrant in which probable cause has been attested. What would be any objection to requiring lodging owners, lodging keepers, whatever you want to call them, that this law would pertain to, in having some record of who is on the property, and then upon presentation of a warrant, providing that information to law enforcement? Because that's the crux of the bill, regardless of all the other changes that might need to be made. This bill specifically deals with providing a warrant for law enforcement, or
Yes.
excuse me, law enforcement requiring a warrant.
Thank you, Representative. And as I said at my opening statement, we haven't really taken a position on requiring a warrant. We obviously will work with law enforcement. We value their partnership. We certainly have seen, and I think you're going to hear in follow-up testimony, we've certainly seen that there has been human trafficking and other kinds of issues that have started to develop into New Hampshire a little bit. So we certainly have some concerns about law enforcement's ability to react to that. Again, we leave that to you all as our esteemed policymakers to figure out what that should look like and what that balance should be. But going back to the keeping of the record, most businesses would keep it anyway, but I do think that there should be some record kept by the business for obvious reasons, right? So that in the event that enforcement has to do some sort of an investigation 3 months later, that there is some record that that can be reviewed to track people's progress in the event that they're chasing a felon or whatever it might be. But beyond that, most businesses would keep the record simply because they're not going to need records of these transactions simply for IRS purposes and other areas that they're required to report or maintain. But beyond that, we're not really adopting a position on the law enforcement aspect of it. We obviously leave that to you.
Representative Terry.
On a lighter note, I trust, as we draw to the conclusion of the Q&A on your testimony, thank you for your testimony, and with respect to the broader concerns that you've raised with respect to Section 353, I would just like to thank you for enlightening me as to the possible reason why, and I believe this is not only the case in New Hampshire but other states. A number of years ago, I have a firm recollection of taking a motel room for the night for a rather reasonable rate of $79 or $99, but when I looked at the back of the door, inside of the back of the door, it indicated that the maximum room rate was over $1,000. Thank you very much. I think I've got it now.
Well, we call it the rack rate.
Well, and if I can respond, I think that's really the problem, right? You post that on the back of a door, and frankly, you have to put in, it might be $99 and it could be $2,500 a night, depending on what's going on. So, and hotels end up putting these wildly astronomical numbers because they don't want to get caught in this thing where, well, that's higher or lower than the posted rate, et cetera. So, the one other thing I was going to add was the discussion around ID. Really a big part of the requirement for the ID is a credit card, right? So you use your credit card to reserve the room, but then you're coming in and you're actually going to pay with a credit card. You're wanting the ID to back up the fact that you are actually the person that has rights to use that credit card. So anyway, I defer. Thank you.
Representative Virgo.
Yes, thank you for your testimony.
You have to pull it close, the mic close.
Oh, can you hear me now?
Yes.
Okay, thank you. Thank you for your testimony. I'm curious, are there any protocols today that you're aware of in the association that if a police officer or any law enforcement agent comes in and asks for this information, what's the protocol today? Is this just information that gets released? I know I can't even find out, like, you know, like if my husband's upstairs, so I'm just a little curious about that.
So currently, again, under the current statute, if an officer comes in and requests it, we're going to share with them information. Most of our businesses would do it in a limited fashion, and usually it would be a case of, and I would defer to obviously the sheriffs, et cetera, but usually they would come in and ask about a specific individual. They're not coming in to just see the entirety of who's in the hotel. But usually that information is shared because I think most hoteliers in the state understand that they're required to share that information with law enforcement. So.
Thank you.
All right, thank you very much.
Thank you.
Okay, Brian. Newcomb, I saved the best for last here for us to tell us why you really are in opposition to this bill.
Perfect. I have a handout of well, I'm not going to be able to fit in the chair, so there we go. Yeah, this belt's not working out well. Thank you, Representative Hunt. My name is Brian Newcomb, N-E-W-C-O-M-B. I'm employed by the Hillsborough County Sheriff's Office for the past 19 and a half years. I'm here on behalf of the Hillsborough County Sheriff, Christopher Conley, and the New Hampshire Association of Chiefs of Police. I'm here to testify in opposition of House Bill 1378 relative to the inspection of public lodging houses. Hotels, tourist camps, and other public lodging provide people with a temporary place to stay. Most people utilize them for reasons such as visiting local attractions, business trips, visiting family, friends, or other leisure activities. Most reasons people use hotels are for pleasant activities. Hotels, however, have people that visit it for more menacing reasons. Hotels provide an attractive place for drug dealing, drug using, prostitution, human trafficking, sexual exploitation of children, white-collar crimes, fugitives, because hotels offer a place of anonymity. I'd like to talk a little bit about the process in which we inspect the hotel logs. A lot of times we're dealing with criminals who have arrest warrants, who are on the run from crimes that could range from the most petty to the most serious. When we are investigating someone that's wanted for a crime, we may go talk to somebody and they may say, hey, Joe is staying over at a hotel in Manchester. So we would go to a hotel in Manchester and we would request to see, the guest logbook to see if his name is on it. However, when you don't have the specific hotel that they're staying at, it's very hard to get a warrant to follow up with that case. Therefore, we're going to all the hotels in Manchester or Merrimack or Nashua or whatever it may be. So it's a very fluid situation when looking at that. The current trend right now is people will rent hotel rooms either under their name or under a friend's name, and they will set up shop to sell drugs or do other illegal activity. Hotels are a busy place, so the uptick in traffic really isn't suspicious most times. And they do that because it's not as suspicious as if they were doing it at their own house, where the neighbors would call or other residents down the street would call if something was out of place. Often these activities are happening in a room right next to a family that's trying to enjoy a vacation or a business traveler. One example that kind of comes to light that just recently happened is a few people got arrested in Milford, New Hampshire for possession of methamphetamine. The investigators over there found out that someone that the Hillsborough County Sheriff's Office had a warrant for was their supplier, and they were staying at a hotel in Manchester. They provided us with the hotel, which was great. Investigators went over to the hotel. We spoke with the innkeeper, who was very pleasant, and we provided them with the name that we were looking for. That name was not on the list. She showed us the whole list, and we were able to identify an associate of his from the list, and we were able to ultimately go up, knock on the door, arrest them, take them into custody, and we ended up finding a large amount of methamphetamine and some other illegal items. Right? That's another a positive spin on how this works. Kind of getting down the sexual exploitation aspect of it.
we work very closely with the Internet Crimes Against Children Task Force. We have an officer assigned to it. We do a lot of cases with them. And over the past year, there have been several cases where an adult has made arrangements to meet up with a minor in a hotel room. Now, when these cases come in, they're very, very fluid. They're very quickly developing. So we were able to identify the hotel that they had planned to meet this minor at, and we were able to go in, ask if their name was there. They showed us the guest logbook. We confirmed that this person was actually serious about following through with his act. Ultimately, that person got arrested at the hotel, but it's just another rung in confirming that this person is really serious about what's happening. Human trafficking, as was spoken about before, is predominantly a major problem at local hotels. And when I say in Hillsborough County, we deal with Nashua, Merrimack, Bedford, and Manchester. Merrimack, I don't know if any of you are from that area, had a tremendous problem with the drug and prostitution. It started about 2 years ago when correct me if I'm wrong, but I think there's 4 hotels that are there, and they were basically dropping their rates to see who could get the most people in there and sell out, which is fine, but it attracts a different clientele when that happens. So we were able to uncover human trafficking cases going on there, and that was simply by going in there and looking at the list and saying, hey, a name popped out to us that we know is a sex worker. It's not uncommon for us as law enforcement to go knock on that person's door and say, hey, are you okay? They may be in there doing nothing right now, but sometimes we've offered services and they've taken us up on those services to get them out of that situation. They're not there willingly, but they are there because they either have an addiction problem or they're forced to be there for some other reason, for money or whoever has control over them. But for them to know that we're around, checking on them, offering them services to the best that we can, and there have been people that we have gotten out of that lifestyle. I'm not saying all of them. I'm saying we do our best to do that. That's a success in my book. And by simply looking at a list to see who's on there to prevent crime is very important. And I want to take the opportunity to talk about what the next step is in that. So if we identify that illegal activity is going on in Joe's room, we're going to get a search warrant to do that. We're not going to nilly-willy go in there. We're not going to blow down the door and do that. We're going to get our ducks in a row. But that list is certainly it's the first level in establishing your probable cause that crime is going on or that there could be something illegal going on or whatever. We are going to put this in front of a judge after that to go to the next step. And I don't know if anyone here has ever applied for a search warrant or dealt with that. It's a very cumbersome process. It takes hours to write, even on the smallest case. And then we do have a new electronic system that's supposedly more efficient, but typically the more emerging situations are put to the top of the list to get signed by a judge. So on a basic search warrant for a hotel guest logbook, I would assume that we would get it back between 8 and 48 hours, depending on when the judge would sign that. Okay, and that's no fault of them. It's a busy nature, and that's what happens. There are many sophisticated organizations that operate up and down the East Coast. I'm sure you have read about it in the paper or watching the news. They travel up here. They go to your local gyms. They steal your wallets. They go to you, and then they take your wallet and your checks, and they go cash them at the banks. That is a huge part of this white-collar industry that's staying at these hotels. And we've had great success when patrolmen are on the street and they're checking the hotels because, hey, we're getting hit with these forgeries and thefts. They check the hotels, they see a name on the list that's associated with one of these organizations, and they're able to either set up surveillance, make an arrest if that person has a warrant, or prevent future crime from happening. I'll bring it up, and this is kind of a public safety issue, is there was a recent double homicide in Bedford, New Hampshire, less than a year ago, 8 months ago. I was there. Those guest logs were absolutely crucial in identifying the victims in that case. They were crucial in identifying people that were not involved in that case and making sure people were accounted for. That was a tremendous help in getting those people out of that hotel safely and effectively and making sure that we weren't looking for someone else that was potentially injured or harmed. And that was a very sensitive crime scene, and I can tell you we were there for days. And that is one of the best stories that I can portray about the use of those logbooks. also, the police shooting that happened in Manchester about a year and a half ago at the hotel there, that was crucial in getting people out of the hotels to get them out of the way, but also who we were dealing with. When you're looking at the logs and you're saying, you know, Joe rented the room, but we know that Joe has the following friends and there's 4 people in there, we think that these people are potentially there. So it gives us an advantage on knowing who's in there when we're dealing with the criminal element. And law enforcement we're not just going to the hotels to just say, hey, who's in the room, who's here, who's there, who's staying here. We all operate with policies and procedures in a professional way, and transparency these days is very important to everybody, and it's important to citizens, it's important to us. When we interact with the innkeepers that are dealing with people at their hotel, it's a very positive experience, and a lot of times it's having a cup of coffee with them, and they're talking about, hey, these are the problems we're seeing. We see this guy coming in here every week, or you know, a lot of people are loitering outside. You know, we may make a recommendation. Hey, maybe you should put some more lighting outside. A couple places have done that, but it's a very positive experience between the innkeepers and ourselves. The current law as they're written allows for law enforcement to inspect a book, a guest book, without a warrant. This is a very effective investigative tool that is often used to combat illegal activity. If the law is changed and law enforcement is required to get a search warrant to review guest logs, this will be a major hindrance in combating illegal activity, allowing criminals even more anonymity. Public safety would suffer if law enforcement needed a search warrant for basic police work. Thank you.
Representative Bartlett has a question.
Thank you, Mr. Chair. Thanks for coming forward and talking to us about real live instances of when it's necessary for law enforcement to access these logbooks. Would it be your testimony that most innkeepers want your help to get people that are breaking the law out of their establishment?
Absolutely. That's their goal and that's our goal. They don't want to have someone that's going to be a problem in their hotel that could be affecting other guests or committing crimes while they're there, maybe damaging the rooms themselves. So they are very positive in that manner.
For the question, you may inquire.
Thank you. So it would be your testimony that this is something regarding public safety. You're not looking, as has been heard this morning, about a quasi-democracy that law enforcement is stepping on individual rights of our citizens.
That's correct. Our officers, investigators, and I can speak for investigators throughout the state and especially Hillsborough County, is caseloads are so high right now that nobody really has time to just go out and check hotel lists on a whim to be like, hey, we're going to check hotel lists and see what's going on here today. It's more of a targeted issue. You're there because you have a case, a reason, and you're following the procedures. And I don't want people to think that we're going to the hotel, looking at their log, and then we're going to kick their door in. That's 100% false. We follow the same rules and regulations as it would be to get a search warrant to establish probable cause to further that case. We're not about violating anyone's rights there, because I wouldn't want my rights violated if I was there as well.
Representative Terry.
Thank you. Thank you for your testimony. I just want to essentially ask you the same question that I asked the previous individual who testified part of it. And I want to understand that, and have you confirmed what I think I'm hearing, and that is that in response to the question, things are different here, different now. They're not like those situations that happened in Germany in the 1930s and 40s, in the Soviet Union under Joseph Stalin, in China under Mao, and questionably in some other countries, perhaps even today, that there's something about the moral fabric and culture of the United States that this need not be a concern now? Is that partly what I'm hearing? Could you speak to that, please?
Sure. I think I should have paid attention a lot more in school when you brought up those names and stuff. My wife is a teacher and should be ashamed. But I do understand where you're going with the question, and I think that we live in a world right now where police transparency is on the forefront of what's happening, and I think that every department in the state has put in place safeguards to accomplish certain measures and means. For an operation to get approved, I have to send it to my boss, and he approves it. I think that it is different now because crime is so rapidly revolving, and it's getting so technical where you could, like the gentleman before me said, you could sign into your hotel room with just your phone, and then you can pop over to maybe rent another room in another hotel with your phone. So you're double insulating yourself with a sense of more anonymity.
Representative Ammon.
Thank you, Mr. Chair. Thank you for coming and testifying before us. You mentioned transparency. Would an alternative to this bill, would you accept an alternative to this bill that would require the police to notify the public when they ask for the records of a hotel, some kind of disclosure maybe on the department's website that they asked the date, officer, and so forth?
So I think if I understand your question, that would be a more of a regulatory protocol as for, maybe on a quarterly basis, or is that like a daily basis? I'm not sure how fluid.
You mentioned transparency, and that was very important these days. It would be transparent of the department if they would notify the public when they went to a hotel and asked to see the records. We would have some transparency in that request.
I would have to speak with some of the other chiefs of police on that so that we could have a better understanding of where we're all at collectively. But a police log would show that we were there.
Representative Greason.
Thank you for answering our questions, Lieutenant. I guess I really have more than one question in all of this. But you use in your testimony that there's an element of people that utilize hotels for darker and more menacing reasons. That can be said about just about everything. Criminals are criminals. They're bad guys. It doesn't matter where they commit their crimes or where they try to hide out. And so does the fact that crimes may occur at a hotel supersede due process of law, rules of evidence, and civil rights? And with that, we've been conflating crimes in progress versus looking for a suspect in a criminal activity that has occurred in the past. And so no one wants the bad guys to get away with their crimes. We all want the bad guys off the streets, and your job is to get them off the streets. But we also have a judicial system in this country, rights, even the criminal has the right of due process of law, right?
That's correct.
So that requires certain actions on your part. You want to make sure the bad guy goes to jail so that the evidence that you collect is within the rules of evidence, and you've dotted all the I's and crossed all the T's, right?
That's
you want
correct.
to put them away. You don't want them to get out on a technicality. So does the fact that these crimes occur at hotels supersede due process of law and the fact that you need to get a warrant? And does a warrant, requiring a warrant, interfere or prevent the innkeeper from volunteering information?
So that's going to be a multiple-part answer to your question. So everyone here has constitutional rights, and no one wants to get them violated because we want these cases to go forth without a hiccup. We don't want anything thrown out on a technicality, as you say. When a hotel room or house is searched, whether someone could give consent to search a hotel room, they could give consent to search their residence. That's not a big deal. However, if we apply for a search warrant, we establish probable cause. We establish that it's been reviewed by a neutral and detached magistrate or judge, and that has been put forth, signed, either signed or not signed. They may say we don't have it sometimes, but it's signed. That gives us the authorization to go ahead and search your room. I think what we're talking here is simply looking at a list of people that are staying in a hotel room that are paying a room and board tax to stay there. I think that is no different than me looking up your address online on a vision appraisal or the tax assessor's website.
No, thank you.
So, before I let you go, you talked about a policeman walking down the street and just walking into the hotel and looking at the registry. Did I misunderstand you that you said that has happened? Just randomly looked at a registry?
I'm sure it has happened, but typically they're there for some reason. I can talk about the sophisticated white-collar crew that comes up. Typically it starts with you may have a bulk theft at Lowe's in Bedford, and it's out-of-state plates, and you may go over to the hotel to see if that car is matching it. You may go into there to see if someone's staying in there that matches a previous.
So,
the bullet.
how often, or have you heard any anecdotal stories where a hotel said no?
No.
So really, this law, even though it exists, has never been used. Maybe.
Well, the law is used every time we go in there.
No,
because
I'm not saying the law is not used because you're not enforcing. You're not saying due to this RSA 355.33, you need to show me your registry. You're just saying is you don't have a problem going into any hotel and having them show you the registry.
Well, I can tell you that about 18 years ago, I did have an issue at a hotel where someone was like, "Oh, I don't know if I can give you those," and I cited this law that we're talking about today.
Yep.
And they had no idea about it, so they were
Right.
educated on that law. But I think that all the innkeepers and the corporate chains have informed and trained their employees on the rights that are respective to each state that they're operating in.
So, well, and that gets me what really scares me about this bill is that most of us don't even know it exists. And my fear is that because we don't have a book or card system, I guess you're looking, when you say the registry at this point, you're looking to say is, do you have a list of all your people who are in the hotel tonight? And I don't. I have a vacation rental. I'm lucky to have just the person who booked it. I don't know anybody else is in the place. So am I in violation of this statute?
If you're renting it out for more than the 2 days at a consistent basis.
2
then
rooms in less than a week, yeah.
Yeah, you
yeah.
would
A
be in-
vacation rental. Yeah, I heard, you've heard about the vacation rentals, right? In the state here, that's kind of a controversy.
Yes.
Yeah. so
like to
so
get
we're
one.
all in violation, but I'm just saying is, so what is a hotel? Does a hotel literally turn the computer around and let you scan through the list, or what are you getting from a hotel?
Typically, what we get is a redacted version. We get they'll print it out, and they usually eliminate all the credit card information and all that other stuff, and you get a list of names in however format that they're putting them out. Or sometimes they'll just let you look at the computer and you move on.
That does seem a little scary about privacy issues, but having the idea that law enforcement can to do this, you've never had, except this one case where a person said, I didn't know this law existed, but in every other case, those people said, yeah, I have no problem showing you or trying to help you and give you all the information you need. Is that correct?
That's correct.
Okay. So we have to figure out how do we make it so that the person who doesn't have that list, how do we protect them from not violating the law and having you say to them, oh, by the way, you just violated the statute. You don't have a list.
That's going to be a task for this committee to research. And I think that there is a lot of work ahead on the vacation end of it with the Airbnbs and the rental. If you have a house up the lake that you're renting on a pretty regular basis on, during certain months, but you're not renting on other months, I think that maybe that should be subdivided out from this into something else, because I think that what you're talking about is it's a very real issue that's going on because of the where technology is with Airbnbs and rentals. I think that's something that maybe should be segregated out because it's
Right.
not as complex.
Well, I'm just saying, but you only have one name. You have the person who booked the room. There could be 4 or 5 people in that room.
Then we would have to do our due diligence to find out if there was a crime committed or if that's even what we're looking for at that end. We simply would have the one room, the one name that's on it, but that's where that first investigative step takes place, that we would have to further our investigation from there.
Okay.
If needed.
If needed. Representative Herbert.
If we passed a law, for example, that said that you cannot actually ask for a list, or somebody says, well, I don't have the list anyway because I don't have to have one, would that hinder your ability to enforce the law?
That would significantly hinder it.
Thank you.
Representative Terry.
So as I understand it, you could ask for the list, and you would see all the names, as well as the name that you'd be looking for. Which leads to my question. I guess I never realized that I do not have an expectation of privacy when I register at a hotel or a motel that it's a transaction between me and the motel and the hotel owner, because hypothetically, law enforcement could come in and ask to see a list upon which my name would appear, whether I'm the person of interest or not, under current law. And this is to Chairman Hunt's point about, you know, do people even know that this exists? I guess I'm asking you to confirm that I do, that the same expectation of privacy and constitutional rights that are extended to me under whatever amendment it is, I can't remember about the right to search and seizure without a warrant in the Constitution, in the section we know as the Bill of Rights. That when I'm temporarily residing in a place of public lodging, that expectation of privacy, it does not exist any longer under current law in New Hampshire, correct?
Correct.
Thank you.
Thank you very much.
Thank you.
Having no more cards, we had, overnight, we had 8 people in support, 1 opposed. And for who testified today, Michael Thornton is for it. Pamela Killing is against it. Justin Rowe is against it. Sherry Kahn is for it. And Elizabeth Sarton for the New Hampshire Association of Chiefs of Police is against it. And with that, we will close the public hearing. This is lunch, before lunch, this is lunch. We're not coming back until 1:15, so that's 1 hour for lunch. That's perfect timing in my mind.
115 looks like just a list of costs, charges for weights and measures.
Do you know anything about weights and measures? Have you ever been there?
Absolutely nothing.
Oh, I do. I've been in the, it's downstairs from the Secretary of State.
Salt.
We're gonna all eat in here?
I'm gonna go get some water.
All right. Boy, they had a platform, didn't they?
Yeah, I know, that was. We were saying about the FBI, they're going around all the hotels in D.C., getting the names of people they know, or the poor boys and all that.
That's
They went through the
what it
list. So these guys are saying, no, you can't do that.
right, come on up and explain this one to us, because as a sponsor, I have no clue.
Okay. Good afternoon, honorable members of the committee. Thank you for the opportunity for this chance to speak. For the record, my name is Cheryl Eyre. I am the Director of Weights and Measures, which is under the Department of Agriculture, Markets, and Food. I am here to speak in support of House Bill 1249. This is a housekeeping item that gives clarity to 2 scale categories and includes 2 definitions that give additional clarity to the proposed changes. The term analytical balance in our current statute is vague as to what category of scale is referenced, since analytical is a term most often used in a laboratory setting. The scale categories in RSA 43810A are used to determine how commercially used devices are licensed with our division. This housekeeping item will clear up any ambiguity by changing the term analytical to precision, defining precision, and adding additional language to the 100 pounds or less category to include the words other than precision scales. So each scale category will be properly defined. Are there any questions? It's really it's straightforward.
Okay, so why don't you tell us what kind of scales we're talking about? Just
Okay,
give us an idea.
so-
What ballpark are we in here?
For the precision category, we're talking about any of the scales that are used in buying or selling precious metals. Sometimes people use those same scales to sell herbs, expensive teas. So that's the kind of scale that we're talking about. So what happened was in the statute.
Can you get a little closer to the mic?
Sure.
Okay, thank you.
One of the categories says 100 pounds or less for that category. So that could be assumed that that included any of our gram or metric scales. We have special equipment that we use to audit those precision scales. And the analytical balance term does not properly reflect those scales because an analytical balance is more often used in a laboratory setting. But these are scales that are actually used in commercial trade.
Okay. Oh my God. We'll start here and we'll go all the way around. Representative Terry, you're up.
Thank you. So as I begin to try to understand what's going on here, and thank you for your explanation, which helps me along the way. Is there a reason why you would retain in line 3, 100 pounds rather than to utilize the more commonly used metric grams or kilograms, given that it's 2022 and not 1852 any longer? Is there a rationale for continuing that and not changing that?
That's an interesting point because in our law, it does allow for metrics to be utilized. When we were looking at defining the term precision, that's why we did in that category define it with both metric and avoirdupois reference. I just did not change the terminology for 100 pounds or less.
Follow up.
Further question.
Would you consider that in the future, given that it's quite prevalent and common in this day and age to use metric measurements which are more precise?
Absolutely.
Okay, thank you.
Representative Johnson.
Thank you for taking my question. Excuse me. So just so I understand this bill, because this is all new to me, would this, when you're talking precision scales, are you talking, I've worked in, the industry where some of the grocery stores and small supermarkets will use a scale to measure their meats to sell. Are you talking these type of precision scales also?
No, that would be in the 100 pounds or less category.
Okay. Thank you.
You're welcome.
Okay, you guys, you're all set? All right. Oh, Representative Hammond.
This is just to satisfy my curiosity. Thank you for taking my questions. Could you tell us about how these scales and different instruments are calibrated and maintained over time?
Okay, so we're required to have any commercial device that is used commercially certified, state certified, every single year. Now, we do this in order to protect the consumer and their interests. We want to make sure that those devices are operating in a proper manner. And so by licensing them in the correct category, we know what type of equipment to utilize to go out and test these devices. Now, if any of you are aware of the National Institute of Standards and Technology down in Gaithersburg, Maryland, they are the ones that put together our handbooks for the National Conference on Weights and Measures. In the NIST Handbook 112, which is an online version now, they actually specify what the examination procedure outlines are when a device is certified. And so we require service companies that are also licensed with our office to follow the examination procedure in order to discern whether those devices are within tolerance and whether they can be state certified. Did I answer your question?
Further question?
Yeah, and then to take that back a step further, the companies that the vendors that you contract with, how do they make sure that their instruments are calibrated? And
good question. So we also require any of those service technicians that are licensed with the Division of Weights and Measures to have their equipment calibrated on an annual basis. So every year they have to have their equipment calibrated. And they report that information to us so that we can track it to make sure that the equipment they are using is appropriate for the devices that they're certifying.
So is that a third party, or do they have that system in-house?
It is, we are working to get some of the ability to be in-house. We have a state metrology lab that is currently working very diligently to get accreditation so that we can do some of the calibrating of that equipment ourselves.
Okay. Representative Petusek.
Thank you, Mr. Chairman. Thank you for your testimony. Would you believe, once upon a time ago, in another lifetime, I used to run a PMEL lab, precision measurement, and we had to have our standards checked by the state and national standards. And when we went out, we had our certifications with us in the book so that we could show the people who had contracted us that their weights or whatever are going to be okay. Also, would you believe, once upon a time, in another lifetime, I worked in a precision chemical laboratory where the balance, the precision balance which was in the glass, and we had to pick up the weights with a pair of tweezers. We could not contaminate them with our fingers. So I know both ends, the gross and the minute, and thank you for your testimony. It's nice seeing somebody from like my old days. Thank you.
Wonderful, thank you.
Okay. Did I see some hands on this side? Okay, we're all set. Thank you very much.
Thank you.
Having no other cards? Just so you all know, this was, we were supposed to be execing today. This was, remember, the exec we did last week. This I had originally scheduled. This was, we were going to get all our bills out, which are already done and they're already on the way. So, right, it did, right. So, okay, and so we have Daniel Richardson is in support of the bill. and of course Cheryl. This is for the bill. And with that, we will close the public hearing. Thank you very much. Thank you all. So just so you know, we don't exec anything in the same day. We're not the Senate, you know. But we will schedule a subcommittee because this is technically under our business category. So you will see in the calendar that we have a subcommittee on it, and then we'll exec the bill. But we just go through the subcommittee process just so we can make sure we know who's going to carry forward with the bill and write the blurb. But you gave us all kinds of good things to write now for our blurb. So thank you very much. Okay. Yeah, yes, John. No, I'm not a John that goes to a hotel. See, I might check my name on the list where we have no privacy, evidently. Anybody can go. Okay, so no, I haven't really thought about that. I mean, to me, execing is when we got, we've done the subcommittees and we got all our ducks in a row and know where we're going with it. So next week we're doing nothing. So the following week we'll schedule, subcommittees, and then I might, I don't know. I have to see how it fits, how it all fits in. I got to take my calendar out and figure out how. I have not done that. I mean, other than the fact that, yes, come March, I'm going to the Caribbean. And that's going to be, what is it, March 9th to it's 9 days, 10 days. So I might miss a session day, so I don't know how that's going to work out, but it is what it'll be. But So that would be, my flight is at the end of the week, so we'll meet that week, a couple of days there, March 7th, let me pull my calendar up. So, right, ninth is a Wednesday, huh? Well, maybe I gotta check my, that's what I thought it was, the 11th, I thought it was the 11th to the 20th. Session days are going to be in there because, theoretically, we have to have everything done by the end of that month. So feel free to not be here. That way we can match up. We can cross each other's votes out. What they call pairing. Senate does pairing all the time.
We're here tomorrow?
Yes. So, Tuesday the 1st, what was 50, what? You say the 1st of March, or? That's a Tuesday, so, no, it would have to be the 2nd. It'd have to be the 2nd. Yeah. Right. It's hoping that they've got it done by then, in terms of getting, Yeah, so again, it would be, Wednesday, Thursday. We could possibly be executing on the 3rd if we get things done by then, yeah. Yeah, exactly, yeah. Right. So I can say that one of our liquor bills, the one that about the multiple computer systems, the multiple point of sale systems. So with that one, the Liquor Commission is working on a bulletin right now to let all licensees to know that yes, they can have just one computer. So that's being done. The food cart thing. Well, there was the two of them. There's the food truck and then the food cart. The food cart issue, what I suggested to the department is we'll have Nano Plus, so we'll have a food cart plus. And a food cart plus will basically take the concept of what do you call it, a commissary. But that the key element I told them is I want the commissary, making sure that the commissary could be somebody's own kitchen or someone in their home, so that they could take this zooped up unit, the actual unit that they're using for selling, that is going to be theoretically going to have whatever, proper heating systems, proper whatever. They could actually take it to where they're going on a trailer, like a lawnmower trailer. They could put it on the trailer, and then they could take it home and clean it out. And I said, and then have the the chili, so you can get a chili dog, you can get whatever. That would be the full-fledged thing. And I said, I understand you guys want to make requirements about that you can't reuse the chili. That once you put the chili in the box, you can't use it the next day. You got to make sure that everything is new and fresh. I said, basically I told them, and they feel very confident they can do this through rulemaking. And that if anything, we'll just have a statute, and whether we need a statute even to say that they'll have this second level. Yep.
I thought the third bill that was presented that day by Representative Aaron would be the one that we could vote on, because it's a study committee to study all the rules and regulations on, food carts and food trucks, and I thought that would be the best way to go. But because you were just talking about, making chili at home. I mean, you can't make chili at home if you're in Manchester and sell it on a food cart. You can't do that because Manchester has a health inspector, and they don't allow homesteading or manufacturing in cities, in homes.
There's part of me that hope that I hear you, and that so, but the part of me is that I would hope that if we were to get this accomplished, that some of these cities would then rethink their policies and reflect the state one. But that would be a state problem. We can't, and that really goes back to this truck problem. I just don't think we can fix the truck problem. Because at the end of the day, the towns want to license and regulate the truck themselves. Those cities that want to do it. We can't stop them from doing that. And the idea that we should have a state license that supersedes that license, I'm not ready to go there. I don't know how many people think that's a good idea, but I just don't think we can do that. So, but that if it is true that some cities refuse to let people have their home commissaries, if that's their city's choice, then that's their city's choice, and all you can do is urge that once we have a state plan in place, to urge them to reconsider their draconian position.
Well, and I imagine anybody that owns a food truck or a cart goes through the Safe Serve program. I mean, that's necessary.
I would assume that, and didn't you say that the Manchester was requiring you to have the state permit anyways?
Yes.
Right. So it seems to me that yes, Manchester's overregulated. If they require you to have a state permit and then get a local permit, boy, that seems a little.
It's because they have a health department.
It's
and
too
that's
much.
in their, I was
It's because they have a health department,
I was
right?
disappointed
Exactly.
that there wasn't anybody from cities here. I know the municipal, what's the
Municipal
lobby?
Association.
Yeah, they were here and then they left before testifying because they were against the bills.
Yeah. But like I say, I'm not sure we can fix that problem because you're at the end of the day, those cities, any city's going to want to reserve the right to regulate and zone, frankly, where they go.
Yeah, zoning's a whole other issue. Yeah.
Right. I mean, and frankly, I think the biggest barrier to that market is what Keith said. It's where you got to find someone who's going to take it and let you park there.
Yep. Yeah, it's a zoning issue.
It's it's more, well, I mean, zoning, it's getting that initial contract. You can drive your truck all around, but, unless you sit at, I don't know, do we allow our state parks, do we allow them to be in the state park?
Nope, I've checked into that. No.
Really? Don't you think it would make sense?
Yeah, that does make sense.
Yeah,
Chairman,
yeah. Well, if the truck had water, but.
you had mentioned that they were gonna try to do it in rules for this hot dog
So the hot
hot
dogs
dog
are-
plus.
yeah.
Is it gonna be another, is it gonna be a more expensive fee?
The fee would have to reflect that there would be more licensure regulation, that they would have to come and check out the kitchen. So it won't be a big fee difference, but yes, there would be a higher fee. Because they gotta rationalize sending someone out to look at it, so.
No, I just.
Actually, the idea that, that they were talking about was, wouldn't it be great that someone could bring their truck, bring it to them? And so that was something that they seen that it's
Yep.
not a bad idea. They're,
Yep.
to, obviously to facilitate that for customers.
Yeah, that was my idea. Why couldn't they just do like, a couple times a year or whatever, where they say all the food trucks need to come in and get inspected.
Right.
Here's your time slot. Everybody goes there. It's less, it's more cost
scheduled,
efficient
yeah.
to have the truck. I mean, the trucks are trucks. Bring it to them. They just do a massive day of inspections.
Right.
They can have water hook up there and plug in so that everything's done right there. Now they know that's certified and it's in a controlled environment and saves everybody time from running all over the state.
Yep. So, all right, good. We'll see you all